Legislation is needed. I think we saw a couple of the senators earlier say the SEC has full authority. It's clear that they don't, and as we've seen throughout the summer, there have been multiple court cases, Ripple, Grayscale, and even Uniswap in a class action lawsuit that basically says that these assets are not always securities, and therefore the SEC doesn't have a role to play. But we do want to have some regulation of the crypto markets, and in order to do so, like Senator Lummis said a couple days ago, is that you have to have legislation in place that puts that framework there. And so I think that the work that is going on in the House right now is incredibly important. Legislation isn't a process that happens overnight. It takes time. And I think that the Chairman McHenry and Chairman Thompson of the two committees are working very hard.
Recent reports claim that Norman Reed, who has worked for both the Securities and Exchange Commission and the Federal Reserve Bank of New York, will take over as CEO of Binance. The FinCEN Doge settlement with Ripple in 2015 determined that XRP should be categorized as a convertible virtual currency. As a side note, the settlement agreement was put under Katie Hahn's signature on behalf of the DOE. On behalf of Ripple, Norman Reed promised to appoint an independent auditor who would provide FinCEN with an audit of all XRPs. This audit would be sent by the auditor to FinCEN. That puts the whole matter into perspective. On behalf of Ripple, agreed in the settlement to employ an independent auditor who would be approved by Deutsche and who would give Vincent with an audit of that. For a very long time, I was under the impression that the SEC and the government of the United States understood more about Ripple than any other cryptocurrency company. The fact that Norman Reed chose to stay with Benels rather than move on to lead is something that could be interpreted as a positive indicator. But there is also the question of the surprising discovery made by Stephen Nirov regarding the corruption of the SEC and Ethereum. This was another issue that was brought up by Stephen Nirov Joe Grunfest, who served as the chair of the SEC in the past, and he possessed the honesty that is no longer fashionable today. As for the number, I have come to the conclusion that it is impossible to ascertain the genuine identities of those who purchased Ethereum during the ICO. This is due to the fact that some people have described how whales were able to do so. However, it is possible that I still possess the author's original drafts of the TOS, in addition to a great number of other documents, recordings, and so on hidden in various locations before the bill and DC legislation was enacted. It's possible that I don't have any major knowledge given the charges that I overstated the part I played in the company's founding, but it's also possible that I do if I had the opportunity to speak with a prominent co-founder. In any event, I suppose that the method that would be most successful in silencing me would be to attempt to have me convicted, publicly discredited, and imprisoned. This would be the most efficient way to silence me. As it turns out, this is exactly what occurred to me for the previous 4 years until I was able to show that the case was made up from the government's own records. I was able to show that the case was made up from the government's own materials. He just demonstrated how corrupt the SEC, as well as himself and others, are, and everything that the XRP community has asserted is true. What exactly does that imply at this point? According to Deaton, he published the timeline of incontrovertible facts and wrote the paper titled Ethereum Free Pass, both of which were published on Crypto Lawyers a very long time ago. Deaton also indicated that he provided the timeline because I presented facts that to this day have never been disputed or otherwise considered to be incorrect in that piece or any other information I supplied. I was labeled a conspiracy theorist. This did not gain me any new friends in the Bitcoin industry. After I shared the information that Jay Clayton had asked Chris Dixon of A16s to organize a small working group and draft a memo explaining what they wanted the SEC to do in January 2018, Chris Dixon of A16s blocked me. The memo was to outline what they wanted the SEC to do, and it was to be given to Bill Hinman. I want to make it perfectly clear that I in no way suggested or stated that Chris Dixon had engaged in any unethical behavior. Despite the fact that XRP was the second largest cryptocurrency by market cap at the time, Ripple was not invited to join this hand-selected small working group, which I did observe. It was apparent that Ripple was not invited to join this hand-selected small working group. Throughout much of 2018, ETH was the second most valuable cryptocurrency and XRP was the third most valuable. However, there have been moments where XRP has been valued higher than ETH, like as in January of 2018, sharing a video that was posted by a digital asset. I made the observation that Hyman was paid millions by sharing earnings from his company, which was a member of the SEC. Hyman was also promoting an initial public offering, IPO, of a company that marketed Ethereum mining equipment. I also took note of the fact that Hyman's attorney Laura Ness said that her client's speech was extremely similar to the document that was produced by a 16Z's attorney. I also saw that Ethereum was the sole token mentioned in the safe harbor that Ness had prepared. Of course, Ethereum was the only token mentioned. The Hyman emails and his deposition testimony showed many of the things that we had said for 2 years about crypto law in the US. We used the efforts of the XRP sleuths to create a chronological video timeline displaying some of the relevant involved players' video clips. This allowed us to prove many of the things that we had alleged about crypto law in the US. 208 years later, after being labeled as conspiracy theorists, we learned that we had been told by SEC ethics to stop breaking the law, but he continued to do so. This information came to light after we were labeled conspiracy theorists. Remember that Joe Grunfest, after assisting Ethereum through Nerioff, wrote to Clayton and the SEC appealing with them not to launch the case, arguing that XRP was a security and there is no one in the world who can question it. He asked them not to file the lawsuit because he believed that XRP was a security and there was no one in the world that could challenge it. However, the general public has been lacking in this one particular aspect up until this point. A genuine insider who was present at the event is aware of everything and has the receipts to back up their claims. It would appear that one of them, Stephen Nario, is beginning to speak with the moral authority of Joe Grunfest, who essentially argued that targeting XRP and granting a pass were morally, legally, and ethically wrong. As a result, I have a suspicion that both my study and the research of my friends is about to get more exciting. In general, I don't disclose the contents of private discussions, but I did contact Stephen Nario to inquire about his availability for the crypto law panel. However, I forewarned him that in contrast to the SEC or him and me, I would not give him a free ride on crypto legislation. Instead, I would ask him challenging questions, such as who the disguised whales are and how they operate. He said that if he does that and keeps a copy of the map that shows the location, things are about to get very interesting. As evidence of his claim, he handed over to me, in accordance with a confidentially agreement, emails from individuals who held positions as far up the chain of command as was reasonably feasible. But I just can't get myself to believe him. I'd really want to talk to him about crypto law at some point in the future. The fact that those same people are participating in the debates when the truth about the Ethereum gate and the alleged corruption involving Hyman and the SEC becomes evident is heartening to us. Someone from outside the XRP community, recognizing the effort that members of the community have put in over the past several years, is undoubtedly a welcome sight and sounds like a breath of fresh air. It wasn't always easy, and there were even members of the XRP community who labeled them as conspiracy theorists, but they persisted and eventually they were successful. You are not merely being uninformed if you believe that BlackRock does not have any investments in Ripple or XRP. Which currency would you prefer to pay with, the dollar or the euro? I saw that I was still being charged 3% for the awful okay. When you consider the number of people that transfer money, keep in mind that some of them may be working in another country and sending money back to their own. That's all for now. Thank you for watching.